I, Leah Boggs, understand that this video is to be of myself on camera completing a speech. A voiceover without my face on the camera is not acceptable. I am now aware how to upload the video I create onto YouTube. I'm also aware that this presentation is not to be read off of a screen or a device. Rather, I must have ownership of the material that I am presenting. I can use notes or index cards to help me remember what I want to talk about. Causation. Causation is defined as the requirement that the defendant is responsible for causing harm and a result of crime. Moore and Worrall, 2022. There are two types of causation: factual causation and legal causation. Causation cannot exist in conduct crimes because a harmful result isn't necessary in a conduct crime. Thornton, 2001. The requirement for causation is a protective function that prevents the prosecution and conviction of innocent people of harmful crimes. In some cases, omission can result in criminal liability because their failure to act can cause harm. Factual causation. Factual causation requires proof that the defendant's conduct was the cause of harm, or else there cannot be any criminal liability. Courts apply a but-for test to determine factual causation by asking and answering the question, but for the defendant's actions would the resulting harm have occurred? Moore and Worrall, 2022. If the court determines that the answer would be no, then the defendant would be held liable. An example of a but-for test would be: Frankie stabs Joe in the head with a knife. Joe then dies before reaching the hospital. We would ask, but for Frankie stabbing with a knife, would Joe have died? The answer would be no, which would hold Frankie liable, which means that Frankie is the factual cause of Joe's death. There can be complications to factual causation that may arise. Using my prior example, if Joe arrived at the hospital alive but then died in surgery that was done incorrectly, this can cause an argument for factual causation. In this case, a medical expert would most likely have to testify in court that Joe would have died regardless from the knife wound, regardless of the surgery that was done incorrectly. Thornton, 2001. In other words, Joe's wound had to have been deadly regardless of failed surgery. Frankie's attorney probably would call up their own expert to testify that the surgery was the reason for Joe's death and not the actual stabbing itself. Concurrent causation can also cause problems in a legal scenario. Moore and Worrall, 2022. Using my prior example, let's say that Frankie also had a friend named Leo over, and they had both stabbed Joe. Frankie stabbed Joe in the head and Leo stabbed Joe in the neck. Joe died in response of both stab wounds. The next question would be, who is the factual cause of Joe's death? Whether we ask, but for Frank's conduct, would Joe have died? Or, but for Leo's conduct, would Joe have died? Both of the answers would be yes, because Joe could have died from Frank, Leo, or both parties. The question now must be redefined as Joe's death by two mortal wounds. With the question redefined in this way, the resulting harm, Joe could not have died without the deadly stab wounds from Frankie and Leo. Legal causation. Legal causation wants to know who should be held criminally responsible. Thornton, 2001. Legal causation also can be called proximate causation. In order to determine legal causation, a fairly simple question is asked: would it be fair to hold the defendant responsible for the crime? Moore and Worrall, 2022. If the answer is yes, then the legal cause would be the defendant. In other words, legal cause of harm is the person accountable of the crime. An actual cause might not necessarily always be a proximate cause, but a proximate cause is always an actual cause. Moore and Worrall, 2022. In order to find out whether something is a factual cause or a legal cause, direct cause and intervening cause need to be defined. Direct causation is when only the defendant is the causal agent that causes harm. More in Worrell, 2022. An intervening cause is something else besides the action of the defendant that caused the harm after the defendant's actions. More in Worrell, 2022. Conclusion. In conclusion, causation is defined as a requirement that the defendant is responsible for causing harm in the result of crime. More in Worrell, 2022. There are two types of causation: factual causation and legal causation. Factual causation requires proof that the defendant's conduct was the cause of the harm, or else there cannot be any criminal liability. Legal causation wants to know who should be held criminally responsible. The requirement for causation is a protective function that prevents the prosecution of conviction of innocent people of harmful crimes. And my references. Thank you.